Korea and Japan have each applied for EU adequacy under the GDPR. 6 months ago, I identified in a couple of articles 4 or more potential problems with each of these applications, but that was written in relation to the directive. My purpose today, to a large extent, is to update those considerations in what is now known in each case in relation to the GDPR and progress that has been made in both countries. Now, I'm going to get to one problem, onward transfers and the effect of APEC's cross-border privacy rules system, which I think really poses quite a danger to the concept of adequacy if not handled properly. But before that, I'll first review the other issues that I raised in those articles. And at the end,
PL&B International Report.
Indeed, published in PL&B International Report. I will, at the end, say a few words about free trade agreements, which poses a distinct but related threat, in my view, to the future of adequacy. Now, I'm not going to suggest any conclusions about the adequacy of Japan or Korea. The European Commission may be focusing on, in fact is focusing on other significant issues that I don't discuss in my articles. And also, adequacy decisions are very complex and lengthy matters not to be dealt with in a short article of a few thousand words. The reports considering those matters usually take hundreds of pages. Now, the first thing I want to raise is the overall question of transparency and the adequacy process. It's my view that wherever possible, within the limits of international diplomacy, the Commission needs to facilitate third-party discussion and debate. And by third parties, I mean people like Professor Bennett and myself, NGOs, industry organisations who will often have very well-informed views about the laws and practices of particular countries that are applying for adequacy. And if they at least have an idea of what the issues being discussed are and key documents that are being taken into account, they can put a lot of valuable input into the final making of adequacy decisions. So for these reasons, transparency is very important, and it is also, of course, very substantively important because adequacy decisions will affect the overall global standards for data privacy, which is in everyone's interests inside and outside the EU. Now, there are a number of other factors here. I say their third parties can raise problems that it may be diplomatically difficult for the Commission to state publicly. Therefore, having outside input is very valuable in that sense. There are, despite the GDPR's length, it often doesn't make clear some aspects of the adequacy process. For example, whether the Commission or the Board must make information public before any final adequacy decision is made, so there can be external inputs into the final decision. Do we even know which countries have formally applied? Bruno mentioned some very interesting things in relation to particular countries with which the Commission is having preliminary discussions. But does anyone know any countries other than Japan and Korea that currently have formal adequacy processes on foot? A bit of crowdsourcing here. No? Well, my understanding, but it's only based on rumour, it might be wrong, Bruno can correct me, is that Mauritius is in the process of a formal adequacy application. But of course, unless we know...
They have expressed an interest.
Sorry?
There's no process.
It's no process. Okay, fine. Yeah, that's to say. I said I don't have any definitive information, but I think it's really important that once there is any formal process underfoot, that these factors be known. Right, so even at the most crucial point, the legislative basis on which adequacy decisions are being made can raise serious transparency issues. So in relation to Japan, there has been no English translation which is public of the Data Protection Authorities, the PIPC, supplementary rules. And it's on those supplementary rules that the decision about adequacy very largely depends, even though drafts have been circulated in Japan for comment in Japanese since April. But there is no English translation formally available. I happen to have one that's come from around about third-party sources. In Korea, the situation is slightly different. There's an amending bill before its legislature, and an English translation does exist.